This is the regularly scheduled meeting of the Collection Service Board. We have Angela calling in today, and with 3 members that'll give us quorum. But to establish that, we'll go ahead and do roll call here. Bart will be absent today. Steve,
present.
Angela Hoover,
here.
And Josh Holden,
here.
And then Chip Hellman. All right, we have quorum. For the, I'd like to start out by reading our notice, and it's as such. Notice of August 14, 2019 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on August 5th, 2019. Since we do have a teleconference today, we'll have to read the statement of necessity, and then all of our votes will have to follow by a roll call vote. So if I may, I'll start out with this statement of necessity. It reads as follows. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is a regular scheduled meeting for the Collection Service Board, and the purpose of today's meeting, with one of the members attending by teleconference, is to discuss the agenda as noticed on the website earlier. That's our regular pre-formatted statement. If someone would, we would entertain a motion to accept that. We will file that with the Secretary of State office as so determined. Do we have a motion in that regard?
So moved.
All right. Steve Harb, we have a motion. Angela, is that a second?
Sure.
Oh, great. All right. Thank you, Angela. For a roll call vote, Josh Holden.
Here, yeah.
I'm messing you up, aren't I?
Yeah, you stumped me there. Yay.
Yeah, I'm tricky now. You got to watch me. All right, so we got Mr. Holden, Steve Harb, and then Angela Hoover.
Yes.
All right, thank you so much. We passed the statement of necessity. We'll get that filed appropriately then. Okay, moving on along, the agenda. Is there any comments on the agenda or any edits? All right. If no, we'll entertain a motion to accept the agenda then. Do we have a motion?
So moved.
All right. Thank you, Mr. Holden. We have a motion. Do we have a second?
Second.
Second.
All right. Thank you, Ms. Hoover. We have a second. For roll call vote, Josh Holden.
Yes.
All right. Steve Harb.
Yes.
Angela Hoover.
Yes.
All right. Thank you so much. We approve the agenda then as is written. We'll move on to the May minutes. I trust you had an opportunity to look at that along with the other documents. Unless you have any comments or edits, you can move to a motion, but of course we'll entertain any edits as appropriate as well. Yes, sir. Go ahead.
I can really raise the question. It's not an edit.
Okay.
The license exemption discussion.
Okay, let me get there.
On that to heard anything back about that?
We haven't just yet. They did receive it, so they are reviewing and preparing that opinion.
I sure would hope y'all just send out a copy of what they say between meetings.
Absolutely.
I'm real curious about this. I really am. Thank you.
I'll make a note of that as well, but we always, when we get that kind of information, we share that immediately. We won't sit on that till the meeting. Okay, great. Any other comments or edits or the like? Okay, we can entertain a motion then to accept the minutes. Do we have a motion? So moved. Thank you, Mr. Harp. Do we have a second?
Second.
We have a second from Mr. Holden for roll call vote. Mr. Holden?
Yes.
Mr. Harb?
Yes.
Ms. Hoover?
Yes.
Thank you so much. We've passed the minutes then. We'll move on to the director's report. We'll take a look at the budget. This won't require a vote. It's just basically a snapshot of our fiscal health. we're only going to really be looking at the last 3 months in particular. We covered everything up through March. So we'll be looking at April, May, and June. And I didn't see anything outside the ordinary there. It looks like everything's trending and tracking accordingly. There wasn't any spikes or dips that created any concern or red flags for me when I was going through the review there. Just to give you a snapshot, then we'll do the year, since we're looking at the total fiscal year, and we'll have the reserve. We should have the fiscal year reserve and a complete budget line item by our next meeting. But for now, it looks like we had a total of $263,811 in total revenue, and then we had $111,410 in expenses. So basically, we're looking at adding $152,401 to the reserve, and the reserve is tracking it's right north of $800,000. So the budget's looking healthy. We don't have any problems there. Nothing that just jumps out at us. Are there any questions in regards to that?
We're having a party every year with the budget being this good.
No, I'll send that inquiry up, and I suspect they'll get back to us right away.
Appreciate that.
All right. Well, that's all we had as far as the budget goes. Yeah, we'll move on then to the application review. The short of the long on this is that, as you know, per rule, we always require that they provide a new applicant, a new initial application, that they submit a summary of their finances for our review. Problem is with that is that occasionally, not often, but occasionally, we will have one that's a startup. So there's not the history there. So all we have to look at that point is their financial backing. We can't really look at prior history. There is no prior history. It's a startup. So we're forced to look at their financial backing to see if they're solvent and if they're viable. From both our subject matter expert and our auditor, they were able to determine that it looks healthy, but again, that's a determination ultimately that belongs to the board. So we want to bring that to the board. I talked to Bart, and he said that this has come up before. And again, financial backing was typically the focus. So I leave that to your discussion.
Did they do a pro forma of what their expectations? I think that's a licensing requirement. Give us a pro forma of what you expect.
They did. They gave us a business plan to that end and a projected
revenues,
yes, sir.
Financial. I don't remember seeing that in the materials, but that's okay. All looked at it from a financial perspective, and I'm sure it's going to look reasonable. It's a pro forma, for God's sakes. Who'd make a
Holden, did you have any comments?
No comments.
Okay. Ms. Hoover?
No, I don't have any. I'm fine with it.
Okay. If we can, then we'll just, for sake of memorialization, if we can go ahead and take a vote. Do we have a motion in that regard to just accept it based on what was provided?
So moved.
All right. We have a motion from Mr. Harb. Do we have a second?
Second.
We have a second from Mr. Holden. For roll call vote, Mr. Holden?
Yes.
Mr. Harb?
Yes.
Ms. Hoover?
Yes.
All right. Thank you very much. One thing I was going to discuss while we're on the application review was right now what we bring to the board are only those pending litigation. If everything checks out with the financials, as you recall, we only bring those pending litigation cases that have moral turpitude or cases in Tennessee. Do we want some sort of criteria to go ahead and resolve these sort of initials, or if they're so scarce, do we just want to bring those to the board as well, like we've done here today? Is that how we want to handle those going forward? Because we haven't really discussed initials like the one we have here before us.
Right up to us in your email to us, you said with application reviews and other programs, one or two board. I don't know that we need to do that.
Those are usually larger boards
Yeah.
that also have a higher volume. Right. So, I think we're okay. I just at least wanted to pitch that to you, give you the opportunity. But I don't, foresee with our volume that there would be a problem. I mean, like again, in 2.5 years, this is our first initial. That's a startup. So
I have a question. Are you allowed to receive a vote when we're not in session? For example, you send the information out and say this is under review. or that basically responds back individually, yes or no. And then you could prove it with that, but would you have to bring that to the board physically in a meeting? Because if we skip a month, somebody could be 5 or 6 months waiting on their license.
Well, obviously, anything that belongs as far as authority to the board remains with the board unless they delegate it. So with the education reviews or a committee, they've delegated that authority to their fellow board members. And so that way, when they do approve something based on the criteria that the board has set and delegated, it's approved that day. And it's basically just becomes, they memorialize it on the record, but there's little discussion at that point. They trust the subject matter experts that they've delegated that to, the review committee, whoever that is, so designated, to make that determination. I couldn't hear you. Sorry, Mr. Harb, if you.
I was just chatting.
Oh, okay, go ahead.
I was inquiring if Josh felt we might consider putting one in place, or Angela, if you feel we might consider putting one in place and at least get 3 people on it so you'd have a quorum voting. But how often does it really come up that we need to do something? I'm a little bit more concerned with those applicants, like the individual licensees that have met all their criteria and ready to go. The process with the collection agency, because of the financials, is somewhat a little bit more drawn out anyway because of the nature of what they're bringing. It requires a few more stakeholders. You're looking at an auditor, so that's not a quick turnaround because of what it requires. It's not, you just don't check for a degree, continuing or qualifying education. It's not just a checkbox where okay, they've met that criteria. I can approve that person. Now they're waiting on a board. With our applicants, that requires a real hardy financial review, and so that takes some time anyway. But my concern is if for some reason the board didn't meet once every other month, it could physically be 5 months somebody waited to get their license approved.
that's possible.
Yeah, I mean, they send it in just before the board meeting.
That's correct.
And doesn't get to the board. And then you go 4 more months. And so it's 5 months before they actually come before the board. I've waited for licenses in my personal history for 2 and 3 months, and that's a long time when you're waiting to start doing business.
Right.
My concern would be, is there something we could do in the event a meeting was going to be skipped? Not that we skipped that many meetings, but we have in the past.
Then we would have to put that apparatus in place where the board would have to designate, like for example, we would send, you could say if 2 or more board members, or at least 2 board members were to approve, then that application is approved. The board has decided.
Memorialize at the next.
Yeah, but then you would memorialize it at the next board meeting. But that application would be approved and would go out, but it would have to be memorialized at the next meeting.
Certainly don't want to delay any applications. Would we have to give a public notice if we were going to do that? Does that count as a meeting, a public meeting, if we're just going to approve an application?
So if you're going to do that via email, if there were more than one of you on the email, of course, that would constitute a public meeting. I think what Glenn is suggesting is maybe sending an application to you, Mr. Harb, and then to you, Mr. Holden, separately.
That's right.
You give your opinion, and if both of you say, yes, it's fine to go forward, the staff would approve that application, and we would memorialize that at the next board meeting.
That's correct.
Rather than allow an application to languish, that would be fine. But it sounds like can we do that on an ad hoc basis, or do we need a written policy?
We would have to, if we decide to do that today, we wouldn't need a policy. We would just need the board to state that they would be willing to do that. And then again, so we wouldn't be in danger of failing to meet noticing a public meeting. We would send that to you individually, blind copy or whatever, so you're not sharing your comments. Your comments would be directly with the staff. Your comments would be directly staff, but not to each other. So we're not in danger of reaching into a meeting. And then once I've collected an approval, let's say from each of you, or Miss Hoover on the phone as she's listening.
So I'd like to see 3 because that's a quorum anyway. Sure. And if only 2 of the 3 did, then sucker has to be held over.
All right. Well, that's fine.
What do you think?
Miss Hoover, did you have any comments that you'd like to add as well?
That's fine. I'm fine with 3.
So if we want to memorialize that, we could do that, and we'll send it to each member, and then if 3 come back and say separately that that's approved,
then that's approved. That application will go out, and then we'll memorialize it on the record. We'll give you basically an education report to show you these were the folks that were approved.
Yes, I like that idea. Let's do that.
All right, that's great. Well, if we can have a motion in that regard, and then we'll get that moving.
So moved.
All right, we got a motion from Ms. Hoover. Do we have a second?
Second.
We got a second from Mr. Holden for a roll call vote. Mr. Holden?
Yes.
Mr. Harb?
Yes.
And Ms. Hoover?
Yes.
All right, very well. That's done then. So 3 members, and we'll get those out of here and then give you an initial application report at each meeting then. All right, very well. Thank you, members. All right, moving on then. We'll take the, looks like we're at the legal and the legal report.
All right. So what I'll do is kind of like in previous meetings, I'll read the number and the corresponding complaint number, and then we'll just go back and discuss any that the board wants to take up for discussion. Number 1, 2019-011151. Number 2, 2019-013371. Number 3, 2019-015591. Number 4, 2019-016881. Number 5, 2019-017611. Number 6, 2019-019921. Number 7, 8, 2019-022051. Number 9, 2019-019601. And 2019-026441. 11, 2019-017171. Number 12, 2019-020781. Number 13, 2019-027841. Number 14, 2019-020121. Number 15, 2019-024801. Number 16, 2019-027401. Number 17, 2019-034121. Number 18, 2019-034331. 19, 2019-033971. 20, 2019-036311. Number 21, 2019-030201. Number 20, 2019-035301. Number 23, 2018-075331. Number 24, 2018-091261. Number 5, 2018-091251. 2018-090601. Number 27, 2017-059161. 8, 2018-011991. Had a little bit, few more than we normally do.
Council, quick question about number 15. That would be 2019-024801. It says that the licensee's license is expired and they don't appear to be in business any longer. Do they have the ability to come back at this late date and attempt to have their license renewed, or would they have to reapply?
It looks like the license expired at the end of 2018. Some we'd have to, but they'd actually have to take an exam, but I don't know for collections is
They would have to submit a new application. The grace period for a collection license is only 60 days.
They would have to start from scratch and do it again. Okay, thank you.
I have a question about number 1. It's more of a request for clarity. The first one, which is 1151, I guess. Conclusion is that you can charge interest because interest is not a fee or penalty. and there's a physician-patient agreement that's reduced to writing. But the only thing it doesn't say is, does the writing that it's been reduced to have to include the allowance of entrance? Or can you just have an agreement in writing that says you'll pay me? It doesn't say I'll charge you interest if you're late, or no late fees apply, and then you apply interest to just an agreement?
Well, and that was one that I almost just, instead of recommending closure, just put it on for discussion, because I'm even sort of split on the Fair Debt Collections Practices Act is pretty clear that it would have to be reduced to writing, and the writing include an agreement between the consumer, the debtor, and the original creditor that interest would be collectible, and it would be collectible to a third party.
Didn't say interest was collectible in the write-up.
Right, and also if we'd had if the complainant had forwarded us a copy of their agreement they had with the doctor or the hospital, whomever, this would have been an easier complaint to answer, I think. And certainly if it said, yes, I agree as the patient to pay any interest. Don't have the benefit of the agreement. And then there's the statute that, to be honest, I wasn't really quite aware of until I read it. And that's the Title 47, Chapter 14, 103, where it talks about all other transactions, a 10%. All other transactions is pretty broad, and that's what this particular respondent, this particular licensee, is relying upon. So, I guess the board could take the position that, well, Fair Debt Collections Practices Act is pretty clear about the collection of interest. This statute doesn't, it is broader, and we could just conclude, have a writing that says you've got to have it in writing with the agreement to collect interest or be on the hook for interest, and just stick with what the FDCPA says.
That's the main thing. That it's a real interesting quirk, but the main thing that bothered me was that the agreement, okay, we've got a written agreement, but it should have to say you can collect interest, just not apply interest to a written agreement that doesn't include interest.
Right.
And that raises another question. If it's a 6-month-old debt, 6 months delinquent, 6 months prior, so it's a year-old debt, no interest was charged, it was whatever amount, and you send it to an agency, will the agency go back and add interest from day one of the invoice? Or will it take it from the time it was applied, given to the agency? Are you going to be able to charge and add it to it?
I think you probably could.
Seem like you could if you can charge interest afterwards and no interest was accumulated. Seems a little aggressive, because if somebody turned in an invoice for $100 and there should have been, and their rate was 15 in the agreement, then you could add $15 to it for a year, start adding $10 thereafter. Originator didn't have interest included in the balance they submit. It go back and add it, because that's what was placed and or purchased. But putting it going forward, that's not terribly unreasonable.
Counsel, do we know what interest rate they're trying to collect? Do we have any idea?
I don't have any idea. I just know the complainant said they're just charging me interest. I think it's, just if I recall, this was a mother who had signed, I think, for her son to get services at a hospital, probably an emergency room, and probably signed just a standard patient-doctor agreement or hospital or physician-patient agreement, however you want to phrase it. Maybe somewhere in there it did say that they were in agreement to pay any interest.
Other issue that's interesting, I think Tennessee has adopted a formula rate of interest that it's otherwise provided for by statute or contract. And I don't know if the interest rate, if you go above that, I think you run the risk of it being usurious. So We don't know if that's going on. That idea to see if we could get a copy of the contract or agreement.
I guess one way, either that, which, we'd leave the complaint and let it, go to the next meeting, or we could just simply take the position that we've sort of taken, I think, before, which is more in line with what the Fair Debt Collections Practices Act has stated, is that if you don't have it reduced in writing, it can come back and say, well, here's the contract, and oh, by the way, it did state it, so,
States it. It
it
states it.
states it.
Yeah.
Yeah.
But applying it going forward, the 10% would be not outrageous. Awfully open, loose end that an agency can charge retroactively. Does it set a precedent for the future?
Well, it would be, I think that it would be somewhat of a change. I can recall of several, maybe a year ago as much, as I believe we issued a letter of warning on a similar, in a similar situation to a respondent, to a licensee who was charging interest, and they didn't have any kind. The consumer had agreed to the interest. But in that particular instance, we knew we had the copy of the contract. So here, we don't.
They've cited this statute. I'd kind of like to know which prong of the statute they think they fall under. Can we punt it out and make an inquiry with them and find out?
Well, we could. I think they're probably relying on just for, I think it's probably the prong 3. I think they're just sort of relying on that sort of catch-all for all other transactions. Initially, we thought this, just as an aside, we thought this was an unlicensed individual they had sent, or company, but we found the license, and then so initially we thought it was just well, it's just unlicensed. We won't even get into the substance of all this other stuff, but they turned out to have a license, and then we had to dig a little.
Here's that they've got a leg to stand on. If they're charge interest just because they said they could.
I can't hear anything.
Sorry. I basically said I don't see any reason to continue with it. It seems pretty straightforward on its face. It just seems troubling to me that an agency can begin to add something to it, a placement or an account that's been sold. As long as they have the contract, they can go retroactively and then go forward adding money to it.
Yeah, I agree.
Yeah, if somebody bought a $100 item or placed a $100 item, that's what you should collect on. But if they placed it with interest accruing, they typically with the placement will say, here's the principal, here's the interest. You get placed both items separately, so you know what it is.
Right.
So if they weren't accruing interest to begin with, I'm just a little trouble with the agency adding it. But, that's if it's appropriate, if it's legal, my being troubled by it doesn't mean anything. I don't know how to leave it beyond that. It seems like it has legs. What do you think, Josh? Do you think it has legs?
Angela, Mr. Harbor's wondering if you thought it had.
Oh, he's talking to me.
Yes, ma'am. He was just.
I agree with what he said.
Oh, okay, gotcha. Yeah, it's hard because you don't get those visual cues, you know.
Yeah, sorry.
No, you're doing fine.
I was looking at you, Angela.
Steve, it's your recommendation. Do you concur with the recommendation of council and just close it?
Yeah. I mean, because I'm troubled doesn't change what it says. It's a very interesting point that you can be added, but it makes sense. So yeah, I'm just leave it as. I don't see how we.
I'm fine with that.
Thank you.
Hoover, did you have any that particularly jump out at you?
No, I don't have any questions about any of them.
Okay. Any other questions from the members?
On number 19, I think the recommendation was either close or issue a letter of warning. It was sort of dealer's choice on there. They've chronically had a negative trust account. That sounds like that's at least worthy of a letter of warning.
Yeah, I agree with that.
I think that was.
Hello, I can't hear.
Yeah, the disciplinary council was discussing the process of opening that. So just more administrative concerns right now.
Oh, okay.
But yeah, letter of warning is why that I sort of gave the board that option, just because I thought that was something that might correct the problem in the future.
Seems reasonable. I'd go for a letter of warning.
I do too.
Vote on that to change it or not. Just request the change.
You can just request a change, and at the very end, we'll just articulate that change as a part of the total vote at the end, since he's already read each of the case numbers.
I have no other questions.
Any other questions? Then number 19, complaint number 2019-03-3971 will be adopted. The recommendation of a letter of warning to be issued.
With that, then the rest of the cases were concurring with council's recommendation, save number 19, which was just articulated by disciplinary council. So, with that, do we have a motion to accept to accept those recommendations?
So moved.
We have a motion from Mr. Holden. Do we have a second?
Second.
Thank you, Ms. Hoover. We have a second from Ms. Hoover. For roll call vote, Mr. Holden? Mr. Harb?
Yes.
Ms. Hoover?
Yes.
All right, thank you very much. We've taken care of the legal report. Then we can move to the legislative update. This will be pretty brief.
We don't have any legislative updates at this time.
As I promised, there you go.
It was pretty.
Yeah. The only item was just debt. I think that was it. But that was passed. You guys already know about that. Not so much an update, but
That went into effect yesterday, actually.
Yeah.
And I sent out the notify for that.
We do have one item for new business. It occurred to me that this year, it didn't occur to me recently, but it has occurred to me that this year is flying by. And so we are looking at another calendar year. And so the meeting dates, I haven't sent these to you yet. I have those, and I will after the meeting. But instead of waiting till November for everyone to look at their calendars, I'd like to present to the board and if some of the dates. What we did was just mirror the dates from this year, so it'll look very much the same. Let me give you those dates right quick, and if we can just do a quick calendar review. And then, of course, if we come back and where there's some scheduling conflicts later that you realize after you get back to your desk, we can do an amendment at the next meeting. But just to go get this on the website would be helpful. February 12th, May 13th, August 12th, and November 18th.
That's fine with me.
Okay.
problem with them. I mean, right now.
Right. And if you do, that's fine. These won't be memorialized for all eternity from today. If we go back into your calendars and you realize that something was to get in the way of what you had anticipated and didn't have on your calendar, that's fine. Just let me know, and then we can make an amendment at the next one. But after today, once voted in, we'll at least get these on the website, and that way folks can start planning their calendars as well.
Those all look clear to me.
Okay.
With just 4 meetings next year, it's the second Tuesday, right? First Tuesday.
The Wednesday. So it'd be we mirrored them after this this schedule. So, right, that's correct.
Then being able to approve one by you all sending it out blank to each of us is more important, because if you got it just before the February meeting and the May meeting was canceled, it'd be August before. That's a long time to
That's
wait.
right. So it was good work today that you folks went ahead and
that would be troubling.
That's right. That we passed that that process review there, that board member review through email, and so we'll take care of that. If we get any ones that pop up, we'll take care of those and get three members to approve, and then we'll of course announce and memorialize that at the following meeting, and these folks won't get delayed. So that works out perfect. All right. Well, we'll need a motion then regarding the meeting dates to approve those. Do we have a motion?
So moved.
All right. Thank you, Mr. Harb. We have a motion. Do we have a second?
Second.
We have a second from Mr. Holden for roll call vote. Mr. Holden?
Yes.
Mr. Harb?
Yes.
Ms. Hoover?
Yes.
All right. Well, we passed the meeting dates. We'll get those on the website then. And again, if we run into any conflicts, please let me know. And do we have any other new business from the members? All right. And we'll look into that party. No, we won't.
News on it.
But the adjournment then, if we can have a motion in that regard. Do you have a motion?
Move to adjourn.
All right. Thank you, Mr. Harb. Do we have a second?
Second.
Thank you, Mr. Holden. For roll call vote, Mr. Holden?
Yes.
Mr. Harb?
Yes.
Ms. Hoover?
Yes.
Thank you. We are adjourned. Thank you, members.
Thank you.
We have a meeting. Our last meeting this year is November, right?